We're talking about the Robert Hur, the special counsel that was investigating President Biden on the classified document issue. But let me be clear about this, and I really think it's important that you understand exactly what our position is. Our position is this, that neither one of these cases should have been brought in the first place, not against Trump, not against Biden, but especially not against Trump. And the fact that they did bring that against Trump shows you the two-tiered system of justice. And that's especially so when you listen to what Congressman Jim Jordan said, the chairman of the committee. Take a listen.
I think this is interesting because here's the scary part. Page 200. I said this earlier in my opening statement. Page 200. Joe Biden, this is a quote, Joe Biden risked serious damage to America's national security when he shared information with his ghostwriter. Shared it with his ghostwriter, the guy who was helping Joe Biden get $8 million. And oh, by the way, Mr. Hur, what did that ghostwriter do with the information Joe Biden shared with him on his laptop? What did he do after you were named special counsel?
Chairman, if you're referring to the audio recordings that Mr. Zwanitzer created of his conversations with
exactly
Biden,
what I'm referring to.
He slid, if I remember correctly, he slid those files into his recycle bin on his computer.
Tried to destroy the evidence, didn't he?
Correct.
Okay, which should have resulted in a separate charge by the special counsel against that individual who was working with the vice president then on his memoir. Andy?
Yes, absolutely. Destruction of evidence, obstruction of justice. Here's a person who got classified information given to him by Mr. Biden in exchange for what? He paid him a substantial amount of money to write these memoirs. So he gave it to them. He shared it with them. He put it on his laptop. And what did he do after he got the stuff? He destroyed it. He destroyed evidence. That is indictable conduct, and Hur should have said that.
Well, I don't understand is why they didn't. Now, maybe there's some kind of within the scope of his mandate, maybe it was outside of it, but it sounds like you usually have that provision that says, or all matters related thereto.
Right. Usually you have a catch-all paragraph.
Had that, and we dealt with that.
Yes, he did.
So, Harry, this is just another example of the two-tier system of justice at play here.
Absolutely. And so if you look at the ghostwriter in particular, it also implicates another very, very important issue, which is Joe Biden's motivation at the time he mishandled the documents. So at the time he mishandled the documents, he had 8 million reasons to ignore the guardrails governing the handling of classified documents. So Joe Biden was scheduled to earn up to $8 million as an advance on a book that he was writing with the ghostwriter. So he had a motivation. And that suggests to me that he had the requisite intent to violate the law. Having said that, I agree with you that no charges should be brought against Biden or Donald Trump.
Biden because he's a sitting president, Donald Trump because he had the authority to declassify. So I think both of these, but the two-tier system of justice here is outrageous. Now, Robert Hur addressed the whole memory issue, and I'm going to play you that soundbite in a minute. What I'm concerned about, though, is, Andy, and we'll play the bite in a minute, is this idea that he's got diminished memory now. What does it have to do with the time of the commission of the alleged crime?
Well, that's a good point. And I think Professor Hutchison mentioned that when you commit the crime or the alleged crime, he had the capacity at that time to understand, the willfulness element was present. The knowing and intentional and willfulness element was present. But at the time that he would be charged with the offenses, which is when Hur's investigation has taken place, Hur concluded that he would come across with a bad memory, and therefore a jury would find that he was unable to form the intent at that time. And when you're prosecuting a criminal case, your duty is to find intent, willfulness at the time of the commission of the events. But if the jury will infer that he couldn't have formed that intent to be willfully destructive of documents, then he probably wouldn't get a conviction. And Hur said, I declined to prosecute him because of that. I probably wouldn't get a conviction in the eyes of a jury.
Was that the right call? I mean, we know he can't be prosecuted because he's a sitting president.
Right.
That I get.
Assume he wasn't. Okay.
Yes,
assume that he could be prosecuted. I would probably do what Hur did. I would say, look, He did it at the time. He knew what he was doing at the time he turned him over. But sitting before that jury, he's going to come across as an old man who doesn't know what he's talking about. He can't remember dates, events, and situations like that. Why would I prosecute him? Because they're going to probably come back with a verdict of not guilty.
Because they'd be sympathetic to him.
Yes, and I'd have to prove his guilt beyond a reasonable doubt.
Right.
So they fasten on his mental memory loss and memory inability and come back with a not guilty verdict.
Let's hear what Hur had to say.
There has been a lot of attention paid to language in the report about the president's memory, so let me say a few words about that. My task was to determine whether the president retained or disclosed national defense information willfully. That means knowingly and with the intent to do something the law forbids. I could not make that determination without assessing the president's state of mind. For that reason, I had to consider the president's memory and overall mental state and how a jury likely would perceive his memory and mental state in a criminal trial. These are the types of issues that prosecutors analyze every day. And because these issues were important to my ultimate decision, I had to include a discussion of them in my report to the Attorney General.
Okay. So what does that mean for the case, Andy?
Well, there's no case. I mean, it means that the case would not go to trial with a successful conviction possibility because of the fact that the president's mental capacity at that time to form the intent, not his capacity to commit a crime. That's the standard there is knowing the difference between right and wrong. That's not the point. He didn't say he didn't have mental capacity to commit the crime. What he said is his memory was so bad when I interviewed him that he would be sympathetic, a jury would be sympathetic to him on the basis that he couldn't form willfulness. And you have to show bad intent when you're prosecuting a crime. Hur made the right call, I think.
Harry, I said earlier there's a two-tier system of justice going on here because Hur says I want to prosecute him even if the policy against not prosecuting presidents wasn't in fact the policy. He wouldn't have prosecuted anyways. Then you've got the actual prosecution of President Trump for the exact same issues, retention of documents, where although he was president and had the ability to declassify. How do you read that situation?
Well, I read that essentially as a basis for concluding that there is a two-tiered system of justice in the United States, and it is grounded in a political calculus. So if we focus initially on the Biden case, in my judgment, there is clear and unmistakable evidence that Joe Biden willfully and intentionally violated the law with respect to classified documents. That's number one. And I think we can show that by at least a preponderance of the evidence. Certainly with respect to the time at which the misconduct initiated. Secondly, I would agree with Hur that it would be difficult to prosecute Biden were he simply a regular American citizen and not president, because his memory is so deficient now that would probably undermine the claim that he willfully and intentionally violated the law when indeed it occurred. But third, I would suggest, with respect to the Trump case, that with respect to Donald Trump, he had classification authority, and that a political calculus was made that we need to bring a lawsuit against Donald Trump now in order to basically paralyze the potential possibility that he could run for office successfully in 2024. So I think
exactly what the Justice Department's not supposed to do.
So I think that's the calculus. Again, I go back to a point I said I made earlier. I agree with you. No case should have been brought against either of these individuals, but we are where we are.